YouTube. Today what we're going to talk about is waiving judicial immunity. The only way to waive judicial immunity is to put your argument and your injury and your violation on the constitutional rights. If you don't connect your injury or the violation to your constitutional rights, then they're still going to have immunity. So the cases is Owen versus City of Independence and Maine versus Thiboutot. Now, there's another case. I don't have it right now. My notes, they were deleted. So I'll get that case to you. But Owen versus City of Independence and Maine versus Thiboutot, two Supreme Court cases. They were from 1980, and they were put on the U.S. reports on 1982. So these two cases prove one point, that when government or officers of the court, that's government, violates your constitutional rights, they have no immunity from liability. So these two cases prove one point. It says, Your Honor, if a citizen can't claim ignorance of the law, how can you go for and willfully violate a citizen's law when you are deemed officers of the court? You are deemed to know the law, to enforce the law. So therefore, judicial immunity is waived. So a lot of people always want to argue when they go to court. It's good to argue. People say don't argue, but I like to argue because when I'm arguing case law. I'm not arguing the facts. That's me. Because the facts are true. They're saying I didn't have a license. They're saying I didn't have a permit. It's true. So I'm not going to argue that. So now there's no trial to argue the facts. But when it comes to law, then they go straight to the law. Request all formal hearings. A formal hearing is where you get all your hearings. But sometimes they won't give it to you even though you request a formal hearing. A formal hearing is usually to establish probable cause, jurisdiction, Ferrera hearings, Miranda rights, all type of hearings, Sandoval hearings, and all that. So the reason you want to waive judicial immunity on the record is just in case you lose, or just in case you win and you want to sue for injuries. So these two cases are very strong and powerful cases. The case for the Supreme Court of the United States. Now, there's a lot of people that don't know how to fight and argue implied immunity, judicial immunity, and there's another type of immunity that they claim that they can't be. So, we did it for good cause. So now these two cases says that it's not good cause. It's good faith. There you go. They saying, well, we had good faith. So people lose their cases on good faith because the police officer says, well, we did it in good faith and we felt that he was violating the law. So with these two cases, good faith defenses are not good. They're not good. So the cop says his tail light was broken, or we felt he was going to commit a crime. And then we searched the car during the traffic stop and we found a gun under the seat, or somewhere where they couldn't see it, but they went beyond the regular original search. You could argue on the Fourth Amendment, but you want to go argue on of course, argue the Fourth Amendment. And then once they get to the gun case, say that you lose your Fourth Amendment and you reserve the right for appeal. Now you want to argue the gun. Okay, now they're going to say that the gun was illegal or lawful possession. Okay, Your Honor, well, this court didn't hold my Fourth Amendment that it was a illegal search and seizure. Now you're saying I had a gun. So now you're on another, you see that? That's cool. Never seen that around here. So you want to argue that that you have a right to possess, and that's under Murdoch versus Pennsylvania, where they say that you needed a license and a permit. You state that no state could convert secure liberty to a privilege and issue a license and a fee for it. And if they do, you got the right to engage in the right with impunity. Meaning, Your Honor, the Supreme Court says I can ignore the license and fee and engage in the right with impunity. So, fine. Other than that, you want to state your objections. But, Your Honor, I feel that they can't have good faith defenses because Owen versus City of Independence and Maine versus Thiboutot states that good faith defenses are not good when they violate constitutional rights. And I'm saying they're violating my constitutional rights. So that you reserve that on the record for that case and for any other future cases that you have to appeal or sue. You know what I'm saying? So that's fine. Just put it on the record. Make your record. When you object on the record as a mistrial, an appealable issue, as a waiver of judicial immunity. So that's how you waive that. Remember, your injury or the violation has to be connected to a constitutional right. So whatever right you have, it falls into some type of constitutional right. Either the right to contract. Remember, a lot of these rights, you're not going to find them in the Bill of Rights, but you will find them in constitutional interpretation. For example, Shapiro versus Thompson, 319 U.S. Shapiro versus Thompson. Request, subscribe, comment, and request information not provided. If you could donate, please donate. So, in this court case, the Supreme Court stated that the constitutional right to travel is such a basic right, it doesn't even need to be mentioned. And when you go to the Bill of Rights, it's not even mentioned. But the Supreme Court says it exists. Just like the right to privacy is not in the Constitution, Bill of Rights, but it exists through Supreme Court interpretation. So you're going to look for that right. Another right, it's the right to family integrity. I found a case for that, where the government cannot interfere. So I'm going to give you an example. The right to family integrity is a substantial and due process right, which cannot be violated. And there's another word, but it says they can't violate it unless the state has a compelling state interest. So when it comes to compelling state interest, is where they compel you to perform, like if you're under a contract. Now, say you get your license, your driver's license, and all gun license and all that. Fine, you sign it, you enter into a contract. But when you sign that contract, you got to sign UCC 1-308 because it's commercial. Everything with a license is commercial. So when it comes to commercial law overall, it's the Uniform Commercial Code. So in the Uniform Commercial Code, UCC 1-308 states that when you enter into a contract, any rights that you have before you entered into the contract are reserved, meaning you didn't waive it. So fine. You go, you get a license, you get a gun, then the license expires and you get caught. Now you get in unlawful possession, right? So now, due to the unlawful possession, they're going to try to prosecute you and all that. So what you would do is you would put in your evidence, the Uniform Commercial Code. You go to their website or you get the book itself, and it states that any rights previously to a contract are strictly reserved. You could put under duress, without prejudice, or UCC 1-308. So that's what you would do. You do that on your license too, because you want to reserve your rights. So now, this is what you have to remember, that when they ask you, did you sign this under consideration? You say no. Consideration is something they must always give. Now, without consideration, then it's usually a contract will be void because there was no consideration given or granted. So if they ask you, did you sign this driver's license or this gun license or whatever liquor license or whatever marijuana license, did you sign this contract? Yes, Your Honor, but it was not out of consideration. It was out of convenience. So convenience means, to me, this is what convenience means. Okay, in this modern times, you're working or whatever contract you have, some people want to pay you in check. So now, in order for you to cash that check, you need a state ID, a government ID, some type of ID that it shows is you. So without this ID, you can't cash that check. You can't get paid. You're going to starve and die, logically speaking. So you say, I signed it out of consideration, because nowadays, nobody would change a check. Not one person would change a check without ID. So it wasn't out of consideration. It was out of convenience, because it's convenient to me. I didn't want it, but I had to get it in order to change my check. So I didn't want to waive my rights. So what I did is I signed without prejudice, UCC, Uniform Commercial Code 1-308. That's the new version. The old version was 1-207. So that's how you reserve that right? That's how you would go about that. So you reserve that right. You got all your rights. Now, push come to shove, you're in front of the court, and you feel they violate your rights. You make your arguments. Whenever they overrule, deny something, you clearly say object on the record as a mistrial, as an appealable issue. So you automatically reserve that for argument at the appellate court or the court of appeals. Usually, the appellate court is the one that has a general jurisdiction. That's the judicial part. You know, the one where they actually look deep into the law and say, okay, was the law violated? How was the law applied? Because they're not gonna look at the facts. So usually, it's very rare, very hard for them to look at the facts. But we're not arguing the facts. We actually challenging whatever statute they used against us. We reserve our right. We're saying that they have no immunity for violating this right. And if it went that far and you do win, you reserved all that. You know, I got my children's dogs, so please excuse my loss of thought sometimes. So now you got the case law. Now you know how to go about it. They say you had a contract, yes, Your Honor, but it was not out of consideration. It was out of convenience. And I did reserve my right under the Uniform Commercial Code and under the Constitution of the United States under Article 6, Paragraph 2, which states that this law is the supreme law of the land. So now, another case law that goes with Article 6, Paragraph 2 is Marbury versus Madison. Now, in this case, the person lost, but the opinion of the court was that the Supreme Court has judicial review, and they can nullify something that's not in accordance or pursuant to the Constitution of the United States. So you reserve all of that, and that's how you go about it. Now, if you got any questions, like, subscribe, and donate, and post your question in the comment. As soon as I get it, I would most immediately and as soon as possible, I will answer that. But like I said, there's no immunity from any government when they violate constitutional rights. A lot of people out here are losing. There's different states where the police stop you, state troopers stop you, anybody stop you from the government, and they confiscate your money and all that. Sometimes they confiscate your guns when you don't have a license or a permit. I will fight that all the way to the end, because you don't know that a police officer may be one of the crooked ones, like the ones that go to jail and prison for violating rights and violating people. You don't know if they're going to take that gun and sell it to somebody, and it has your fingerprints, and now a murder gets committed. So you're going to want that back. Your Honor, I want that weapon back. I got a constitutional right to possess it, and I want it back. I don't know if these cops can go around my back and sell it and then try to tie me up for a murder or a shooting that I didn't commit. So you state all that, and you fight everything with Constitution. And whatever injury you have related to a constitutional right. Now, there's cases where the judges, including the Honorable Judge Justice Scalia, rendered two opinions in two different Supreme Court cases, and they relied on the interpretation of the Black Laws Dictionary. So be careful on what dictionary you use, because there was one time where a person was using a Latin dictionary, but the person that was doing the dictionary, he just started adding a lot of Latin phrases, and then they did a recall in that, because if that's the case, I just might as well learn Latin. You know what I'm saying? But no, it doesn't work that way. So that's what happened. So always do that. Make sure that you're focused. Make sure you establish that if you do prove that they did violate your rights, they have no immunity, and that a good faith defense is not going to stand when arguing with us or fighting with us. Thank you, guys. You're welcome.